Hello, everyone, and welcome to Uncivil Law, where we learn through the misfortunes of others. If you're enjoying our legal education content, please remember to subscribe. It helps the channel grow. For today's case, we are dealing with some people who were concealed carrying and were shot by the police, and we're looking at whether or not it was a fair shoot or not. This is the case of Aubrey Williams versus Daniel Aguirre. In this case, some people decided to go to a convenience store very early in the morning after probably drinking and were concealed carrying, confronted by the cops. It didn't go well. We're going to learn some more stuff about it. Let's get started with this. In the still dark hours of a morning on April 2014, Williams and Devin Brown awakened after an evening of playing video games and decided to purchase snacks at a nearby gas station. They're gamers too, man. Both Williams and Browns carried a concealed handgun, though Williams lacked the proper permit. After Williams and Brown purchased their snacks, officers Aguirre and Halsiki of Birmingham Police Department arrived at the gas station to investigate a reported robbery at a nearby bank. That's just bad timing. That's just really bad timing. So apparently, simultaneously to this, there was also a bank robbery very early in the morning or something. So when they questioning someone outside the officers saw Williams and Browns looking at them. Williams moved his gun from his hip and placed it in a grocery store bag he received for his snacks to conceal it to the firearms, because apparently he was open carrying. So he decided to move it to his grocery bag. Great. He and Brown then left the gas station and walked into a nearby alley to avoid getting messed with by the police. Williams and Browns did not get far. The officers followed them in a squad car and ordered them to lie on the ground. Perhaps they saw the gun moved or something. Maybe that's what happened. When Williams and Brown failed to comply with the order, the officers approached them. Although Brown denied having a weapon, one of the officers saw a handgun in the pocket of his pants. The two then scuffed at Halsiki and tried to grab Brown's arm. Aguirre then tasered Brown, who fell to the ground, and Halsiki began handcuffing him. So yeah, this is not going really, really great over here in Alabama. These two kids, brothers, apparently, after an evening of video game, we decided to go to a convenience store, and very bad timing. Apparently, a nearby bank had just been robbed. And the officers see these two people and may have saw their firearm, because apparently one of them was open carrying at the time, and think, maybe these people might be involved in some way, which, I guess. It seems strange, but stranger things have happened, right? So the officers then confront these guys and say, get down on the ground now. And the kids decide, instead of complying, how about I don't comply? And how about I get into a scuffle with the officers? This is going about as well as could be expected, so let's read on. So then, as Williams was turning, Aguirre jumped back, fired his gun, and shot Williams. Aguirre then kicked away Williams' gun and handcuffed him. So, yeah, that was great. So some of these events were captured on a dashboard camera in the squad car, with Aguirre activated after securing Williams. Because the camera uses a buffer system that preserves footage for 60 seconds, it captured the final moments leading to the shooting. Nothing we view in the video conflicts with Williams' account. So the officers are telling a story, and Williams is telling a story, and Williams says, here's a whole bunch of things that happened, and none of the videos conflict with what Williams said, but Okay, so we got a couple of kids, we got a couple of officers, we got some kind of scuffle, we got some kind of videotape, we got one of the kids has been shot by the police, and now we have to figure out what happened. What did the police see? What didn't they see? What happened? So now we're going to have to adjudicate all this and try to figure out, who did what to whom and who did it bad, and did the police do it bad? So let's figure out whether or not the police did it bad. So to figure out whether the police used excessive force, right, we would try to figure out what the information they had at the time is. All right, so let's figure out what information they had and what stories did the police tell. Let's read some more. In the hours and days after the shooting, the officers provided a series of statements that presented dramatically different narrative than from what Williams said. So Williams, who was shot, has a story, and the officers have a much different story. And you might notice from earlier, the court said the video didn't contradict Williams' version. Does it contradict the officer's version? So here's what the officer said. The officer said that Williams had pointed his gun at each of them, which had led Aguirre to shoot Williams. The statements eventually led to criminal charges against Williams for attempted murder. So the police say, aha, he pointed the gun at both of us. So we shot him. So the state said, okay, we're going to charge him with attempted murder. The officers then gave 3 statements on the day of the incident. In an interview with Birmingham Police Detective Rodney Rogers, great name, one of the officers stated that Williams backed up and pointed a pistol at him after Aguirre had tased Brown. The officer stated Aguirre yelled, "Hey," to Williams, which led Williams to turn and point the pistol at Aguirre. Aguirre then pulled his pistol and shot twice. The other officer also submitted an arrest report that offered a very similar narrative. So the 2 officers have their story straight. They say that Williams pointed a gun at us and we shot him. But there's a dash cam. What does the dash cam have to say? The officer's narrative evolved, is one way of putting it, after they saw the video from the dashboard camera, which showed Williams was on his hands and knees when Aguirre shot him. So there's that. So Williams, maybe not so much with the standing and pointing a gun at the police officers, because in reality, Williams was on his hands and knees. So Williams could not have pointed a gun at both of them immediately before the shooting, because, on his hands and knees. The statements on the day of the shooting, which occurred before the officers saw the video, asserted that Williams pointed a gun at each of them once while standing, which led Aguirre to shoot him. But the accounts shifted in ways that brought the narrative closer to the video. So the officers said, aha, Williams was standing and pointing a gun at both of us. And then the video says he was on his hands and knees and doing neither of those things. So, there might be some contradiction there between what the officers say and what Williams says. The officer's next statement came 4 days later in an interview with Sergeant Rodney, another Rodney. We got 2 Rodneys in this picture. We got Rodney number 2 of Internal Affairs of Police Department. Haluska told this guy that Williams had pointed the gun at each officer before the recording started, and the video showed Williams pointing a gun at Aguirre for a second time. Specifically, the officer stated that Williams first pointed the gun at him, which led Aguirre to yell, "Drop the weapon." Williams pointed his gun at Aguirre, but then went down on his knees like he was going to comply, at which point the video started recording, at which point the officer then shot him. Aguirre, in contrast, told the sergeant that Williams had pointed the gun at each officer immediately before the shooting. So now the officer's statements aren't consistent with each other. This officer said that Williams had his bag in his left hand, a plastic bag in his left hand. He set the bag down and he came up with a black firearm pistol and pointed at my officer, at which point I yelled several times to drop the weapon, and started pushing him. Williams then pointed the weapon away from the officer and pointed towards me, and fearing for both of our lives, I jumped back and engaged by pulling my city-approved weapon. 6 days after the shooting, each officer filed a written statement. Aguirre repeated the account that he gave him to the Internal Affairs. Williams put a plastic bag on the ground with his left hand and came up with a black pistol in his hand. Williams pointed the weapon at the other officer. Fearing for the safety of the other officer, I yelled, "Drop the weapon," several times and started to push Williams. Williams then pointed the weapon at me. When I stepped back, drew my weapon, and engaged Williams by firing 2 times. The other officer, however, changes his story. So the other officer changes the story and now says this. In his story, Williams was on his knee the entire time. So the other officer says, oh, no, wait, he was on his knees the entire time during the entire thing. Now the officers don't agree with each other. I looked and I saw Williams pointing a pistol at me. The officer yelled, "Drop the weapon." Williams was on his hand. He was on his knees and still had a pistol in his hand. Aguirre was walking up to a place William in handcuffs when Aguirre pointed the pistol at the officer. The officer jumped back and filed 2 firearms. So yeah, it seems like these 2 police officers keep changing their story, as the video evidence doesn't back their story up, and they keep changing them inconsistent with each other. Oh, he pointed a weapon at me. Oh, he was on knees? He wasn't on knees this whole time. He was on his knees the whole time. Wait, what? What's happening here in Alabama? Not quite sure. So we can believe 2 things at the same time. You ready to believe 2 things at the same time? I fully believe these 2 kids are complete idiots, because it seems to me that some version of this, there's a little bit of this that's on the kids in some way, right? It seems like things were not going completely great. So these kids are a bit stupid. Also, we can also simultaneously believe the officers used excessive force. You know, what they should have done, is immediately complied with the officers, and but that doesn't seem to be what happened, no matter what story you believe. But the officers now are no longer credible, so we're having trouble believing their side of the story. So there's that problem. So let's press on. Unable to make bail, Williams remained in jail for 16 months because remember, we're charging him with attempted murder. All right. So we're charging him with attempted murder, and he's not able to get out on bail for 16 months. All right, so after Williams was released, because he did finally post bail after it was reduced substantially, a local news organization obtained the dash camera footage and posted it. So up to this point, the dash camera footage was not available to the public. And afterwards, the Birmingham Police Department suspended an award it gave to Aguirre for his actions during the encounter. So that's a nice trick. So the Birmingham Police Department actually gave Aguirre an award for how well he handled the incident. And then the video was released to the public. And the police department, which presumably had the video available before because, it was the police department's video, maybe they hadn't seen the video somehow. And now we're only just learning it for the first time on the news because it was police department video. So they had no way of seeing it before. Yeah. So after they saw it, they revoked the award. So nearly a year later, the district attorney dismissed the charges for the attempted murder. Although the district attorney did not explain his reasoning, his office issued a press release that they're unable to meet the burden of proof beyond a reasonable doubt. So, once the dash cam video came to light, the police had second thoughts of it, but it took the district attorney another year. Say, maybe we can't really prove beyond a reasonable doubt on the attempted murder with the inconsistent stories and the guys with the knee on his knees. Maybe we're going to have trouble proving that one. So anyway, so Williams over here now wants to sue the police officers. He wants to sue the police officers for being shot and the excessive force. So let's figure out whether or not Williams can sue. Let's press on. Williams filed a complaint in district court that accused the officers of deliberate fabrication of evidence and submission of false reports. So Williams is like, you guys knowingly lied, and that kept me in jail for 16 months. So he alleges the officers lied when they say they pointed their gun at them, and their lies cost them to suffer 16 months of jail. He asserted claims of malicious prosecution against the officers. The officers moved for summary judgment based on qualified immunity, everyone's favorite doctrine. They asked the district court to discredit Williams' narrative of the events because they contend the video from the dash cam footage proved that he was holding a gun when Aguirre shot him. They also argued that the probable cause to arrest Williams for carrying a concealed firearm without a permit entitled them to qualified immunity. They had arguable probable cause to arrest Williams for attempted murder, even under Williams' version of the events. And they did not cause injury because of the involvement of the district attorney and grand jury severed the causal chain. So as to the last part of, we are not responsible for you being in jail. We're not responsible because it was the DA and grand jury that put you in jail, so don't blame us. As for the other stuff, we could have arrested you for, the attempted murder and the concealed carry. So what does the court have to say about all that? The district court denied the officer's motion. It ruled that video footage did not resolve whether Williams was holding a gun. So the officers said the video footage clearly shows him holding a gun. And the district court is looking at the video and saying, I can't see a gun. So, there's that. Probable cause for an uncharged crime could not defeat Williams' federal claims. The officers lacked probable cause for attempted murder under Williams' version of events. And the officers' alleged fabrication preserved the causal chain. So even assuming the district attorney and the grand jury would normally sever the chain, which is a premise that isn't necessarily being granted here, but assuming it would, the fact that you lied or allegedly lied would keep the chain going. So qualified immunity shields public officials from liability for civil damages when their conduct does not violate constitutional right that was clearly established at the time of the challenged action. Williams argues that the officers violated his clearly established rights under the Fourth Amendment to be free from unreasonable seizure as a result of malicious prosecution. The officers argue that Williams failed to satisfy his burden to establish a genuine dispute of fact as to whether he was seized in violation of the Fourth Amendment. Really? I mean, he was pretty clearly seized, but okay. They contend that they had probable cause to charge Williams with carrying a concealed firearm, and alternatively, at least arguable probable cause to arrest him for attempted murder. In support of these arguments, the officers contend that because Williams admit his gun was on the ground within reach of him when he was shot, which I'd like to argue is distinctly not the same thing as being in your hand. Being on the ground within arm's reach is not quite the same thing as being in your hand. So therefore, a reasonable officer could have seen it and inferred Williams had drawn the gun to shoot him. Sure, yeah, okay. So let's get this straight. It's not that I saw the gun in his hand. It's I saw the gun on the ground and I inferred that he drew it and pointed at me based on that. That's a lot of inference, man. I mean, it's plausible, I guess, but it's a lot of speculation in that one. How else might the gun have gone on the ground? I can think of a couple other ways that seem plausible too. The officer's argument they had probable cause to seize William for unlawfully possessing a concealed firearm assumes the claim of malicious prosecution is subject to the any crime rule, which insulates officers from false arrest so long as probable cause exists to arrest them for some crime, even if it wasn't the crime that occurred. If any crime rule applies, then the officers prevail in light of the admission they had probable cause to detain him for carrying a concealed firearm without a permit. But without the any crime rule, the admission is irrelevant because Williams was detained on charges of attempted murder. All right. So first of all, we have to get to the law, which is always a good place to start when we're doing a legal education channel, right? So there's a dispute, all right? It's a dispute. When the officers arrest you, do they have to arrest you for what they think they're arresting you for, or can they arrest you for anything, even if they don't necessarily know? So they aren't arresting at the time for concealed firearm without a permit because apparently the officers didn't see the gun be moved into the bag or didn't see the firearm or something. So at the time, the officers conduct their initial stop, let's call it a Terry stop. At the time they conduct their initial Terry stop, they're unaware that they're concealed carrying. So it then flows that the detention can't be for the concealed carry. But one of them is illegally concealed carrying. He doesn't have a permit. So the question is, do the police need to know about the crime that they're arresting you for, or can they get lucky? Can they luck their way into an arrest? So do they have to have probable cause as to something that they think that they arrested you for, or probable cause, would theoretical probable cause of any crime be enough? So we have to figure out which of those two universes we live in. So let's do that. Whether the any crime rule extends to a malicious prosecution claim is unsettled. Our sister circuits have split on this question. And although we've assumed the any crime rule applies in malicious prosecution cases, we did so only under the erroneous premise that a seizure without legal process, which implicates the rule, could sustain a claim of malicious prosecution. At common law, the probable cause element of malicious prosecution developed in the shadow of competing interests. The tort descends from an ancient line of remedies for false accusations. At common law, probable cause was specific to each accusation. English courts refused to allow accusers to raise the existence of probable cause on charges of other charges as a defense to liability. So in the English law, not so much. Probable cause exists or doesn't as to every charge. So you can't say, there's probable cause of other things to avoid liability for probable cause of some things. So the English courts separated this. So they said, here's 5 different things you arrested them for. Just because you have probable cause for one of them doesn't mean you have probable cause for the other one. So we can analyze them all independently. How about that for a nice idea? All right, so that was the English rule. The American courts adopted this framework and likewise concluded accusers could not shield themselves from liability by establishing probable cause for other charges. So much like the English before us, the Americans, which adopt the English rule, because of course we did, said that, probable cause is to each thing unto itself. Everything has to be analyzed on its own terms. And you can't say, we have probable cause of other things. That doesn't help you with probable cause for this thing. As part of the delicate balance between encouraging valid criminal complaints and discouraging false ones, the tort of malicious prosecution requires plaintiff to prove the absence for probable cause for at least one charge in an indictment. The any crime rule threatens to destroy that balance by allowing defendants to escape liability by uniting groundless accusations for which probable cause might exist. So there has been a bit of a dispute on this in more recent times where the courts are somewhat split on malicious prosecution. So the courts are split on this issue. They note that the English rule was probable cause, everything unto itself. And some American courts were like, well, maybe it's okay, or maybe not. But there's a circuit split. So the Supreme Court at some point, maybe? Yeah, but maybe. But not for today, because that's not going to be the issue here. We also acknowledge that the any-crime rule undisputably applies to warrantless arrests under the Fourth Amendment, but warrantless arrests offer little guidance as to how we should evaluate seizures pursuant to a legal process. For warrantless arrest, an individual seized is no more seized when he's arrested on several grounds rather than one. So the only question relevant to objective reasonableness of seizure is whether there's probable cause for some crimes. Regardless of its applicability to warrantless arrest, however, the any-crime rule does not apply to malicious prosecution under the Fourth Amendment. So, again, there's a bit of a dispute here, and this circuit splits and says the answer is the same rule as in English law. So, the idea is false arrest versus malicious prosecution. In false arrest, maybe any reason is enough because you're no more under arrest for one more than the other, which kind of makes sense, right? You're not more arrested because of more crimes. Now, if you're charged with more things, prosecuted for more things, there's more liability because there's more prison time, more exposure, right? So that's not quite the same thing. It's not to say you're arrested for one thing is the same no matter how many things you're really arrested for. Kind of true. To say you're indicted, no matter how many things you're indicted for, are less true. The nature of the indictment is a little different. So this court, we split and say no. You can't do this in malicious prosecution. So the malicious prosecution claims get to go ahead. How exciting. To prevail on the Fourth Amendment claim, Williams must establish the legal process that justified the seizure. The arrest warrant that listed 2 charges for attempted murder was constitutionally infirm and the seizure would not otherwise have been justified without a legal process. Williams can prove his arrest warrant was constitutionally invalid if he establishes that either officer who applied for the warrant should have known his application failed to establish probable cause, or that an official, including an individual who did not apply for the warrant intentionally or recklessly, made misstatements or omissions necessary to support the warrant. Okay, so having determined we can, at least theoretically, prosecute for malicious prosecution, right? We have to determine how would we determine if a prosecution is malicious? And particularly, how would it apply to these officers if it's malicious? What are the officers' exposure for this malicious prosecution claim? All right, so first of all, it has to not be supported by probable cause, right? So how do you know? Well, if these officers made any statements or omitted critical statements that would have caused the warrant to not be issued. So it's infirm if you establish that the warrant should not have issued. And it should not have been issued if it's based on lies. So that would be where these officers are potentially exposed because they might have told lies, and those lies might have been in the arrest warrant, and that might be a false arrest now, mightn't it? Yeah. All right. Williams has presented a genuine dispute of fact about whether his seizure was unconstitutional or not. He does not contend that the officer who applied for his arrest warrant should have known the applicant was invalid. After all, neither of the officers was the complaining witness who applied for the warrant and who would be liable if a facially invalid warrant application. So the officer who actually applied for the warrant is in the clear because he's neither of these people. Williams instead argues the warrant application falsely reports that he presented a firearm and pointed it at the officers. No one contests a genuine dispute of fact exists over whether the statement is false. Williams says he never pointed the gun. The officers maintain he did. So, of course, because we're on a motion to dismiss, we assume the facts in the light of the non-moving party. So thus, we assume the statement is false. And we consider whether this made intentionally or in reckless disregard for the truth, and if so, whether after taking it out, the affidavit is insufficient to support probable cause. So it's not, it may be sadly or not, it is not enough to prove the officer lied in the warrant. You have to prove that the lie mattered. So if you tell a lie and it doesn't matter, then it doesn't matter, I guess. So you can tell lies. The question is, after you remove the lies, is the warrant still sufficient? Does the warrant only exist because of the lies? Okay, so let's do that. Williams bears the burden of creating a genuine dispute about whether the officer's accusation against him was intentionally false or not. And for example, a mistaken belief on the part of the officers, general attacks upon a defendant's credibility are not enough to meet this burden. Instead, Williams must identify affirmative evidence from which a jury could find the officers lied when they stated they pointed the gun at him. We agree with Williams that the record presents a genuine dispute about whether the misstatement in the warrant was made intentionally or recklessly for a disregard of the truth. Although the question of whether Williams pointed a gun at the officers is distinct from the question of whether they lied, which is true, right? Because one is a factual claim and one is a knowledge claim. So this is a difference between a falsehood and a lie. right? For something to be lie, it has to be knowingly false. So whether the gun was in fact pointed at him and whether the officers lied about the gun being pointed at him are two distinct questions. Because one is a purely fact question. Was the gun in fact pointed at them? The other goes to the mental state of the people making the statement. Did the officers believe it was pointed at them? Or when they said it, was it knowingly a lie? Those are different things, right? So they are distinct, but they're nevertheless closely related. The officers detail a multiple-step progression of events between when Williams allegedly drew his gun and when they shot Williams. Under one account, for example, Williams first pointed his gun at each officer, then went onto his knees, and then pointed his gun again. But almost none of these events could have occurred if Williams is correct that he never drew his gun or pointed at officers, and the chances are low that both officers are subjectively mistaken about every event in the series. In other words, the record supports an inference that someone is lying. So that's a nice burn from the Court of Appeals. And you have to kind of read between the lines on this one to reach the conclusion the Court of Appeals thinks the officers are lying. The Court of Appeals is not going to say it overtly because the Court of Appeals is not the trier of fact, right? So you have to read between the lines. And the way that this is reading between the lines, the Court of Appeals seems to be fairly convinced that the officers are in fact lying, right? So what the Court of Appeals says, well, it's unlikely both officers are subjectively just mistaken, right? I guess that would be the alternative to lying. They're mistaken, but they're both mistaken. So the record supports the contention someone's lying. We're not going to tell you who it is, but it's the officers. Hopefully you can read between the lines on that one. And if the jury credits Williams' testimony that he did not draw his gun, it could also infer that the statements are false. Hence, says the Court of Appeals. Hence. You could infer they're lying. The officers fail to maintain a consistent narrative reinforces this conclusion. You could infer it. Just a suggestion. Trial court, you do you, but, we're not telling you what to think, but, just letting you know, you could infer that if you want. Yeah. A reasonable jury could infer from these inconsistencies officers' statements were intentionally false. The jury could find the initial statements differed from the video in ways that suggest more than a reasonable mistake, such as whether Williams was standing when the other officers shot him. It might also find the officers' shifting narrative reflect an attempt to reconcile their statements with video. In short, a reasonable jury could find the officers lied when they accused Williams of pointing the gun at them. Yeah, again, you have to read this with the appropriate amount of reading between the lines, although the Court of Appeals is making it pretty plain. So if you're not seeing the between the lines on this one, I don't know what to tell you. But there's a whole paragraph of, here is what we think. Now, we can't tell you here's what we think because it's not our role. We can't tell you this thing. But what we can tell you is here are a whole bunch of inferences and conclusions a reasonable jury could make. Reasonable jury. So reasonable jury, you could look at this and say, these are inconsistencies, and these people are lying and making up stuff, and the shifting narratives reflect an intent to deceive, and all the rest of it. So we're not going to tell you, but you can probably figure out what we think. We think the officers are lying, so, To overcome qualified immunity, a plaintiff must also prove defendant violated constitutional right that was clearly established when the violation occurred. Williams contends, and we agree, that under this version of the facts, the officers violated clearly established rights under the Fourth Amendment. More than 3 decades before officers accused Williams of attempted murder, the Supreme Court held a search warrant was void when the officer's lie was necessary to establish probable cause. By the time of Williams' detention, we've concluded the law is clearly established. The Constitution prohibits a police officer from knowingly making a false statement in an arrest affidavit about probable cause for an arrest in order to detain a citizen, if those statements are necessary to support probable cause. So yeah, the idea of whether or not it's clearly established at the time, the officers can't lie in their they can't lie to the court. Because Williams has established a genuine dispute over whether the officers violated his clearly established rights, the officers are not entitled to qualified immunity as to this stage of the suit. The officers then argue that state agent immunity defeats Williams' claim. So having given qualified immunity a try, let's give state agent immunity a try. Let's give that a shot. Okay. State agent immunity shields government officials from acting within discretionary authority from liability unless federal or state laws enacted or promulgated for the purpose of regulating activities of the government require otherwise, or the officer acts willfully, maliciously, fraudulently, in bad faith, beyond his authority, or in a mistaken interpretation of the law. Williams argues, and we agree, the officers are not entitled to summary judgment because of state immunity, because of genuine fact disputes about whether or not the officers were in fact malicious. So, you have immunity, but not this much immunity, and there's enough to think that maybe you guys were doing this intentionally, purposefully, maliciously, and deceptively. So we think, we can go forward. We thus affirm denial of qualified and state agent immunity for the officers involved in this shooting. Thus, that brings us to the end of the case of Aubrey Williams versus Daniel Aguirre and Richard Haluska, the officers. In this case, the 11th Circuit Court of Appeals burns the officers alive at the Court of Appeals. They look at their record and they're like, yeah, the district court denied qualified immunity, and the officers are sad and they'd like their qualified immunity and state agent immunity. And not only do the Court of Appeals deny it, but they basically say, we do not believe the officers. They are lying. They are full of crap. They lied. They lied to the courts. They made stuff up. They're doing it on purpose. So, not that we're going to tell you what to think, but, a jury could conclude this. Just some thoughts. So, yeah, they send it back down to the district court for a trial where a jury will have to figure out if the officers did lie. And for the moment, at least, that brings us to the end of the discussion of this case. Thank you so much for being part of the Uncivil Law family. If you enjoyed this legal education content, please hit the subscribe button. It really helps the channel grow. We appreciate your continuing support. And until later, my friends, cheers and goodbye.